Okay, good morning, everyone.
Good morning.
Okay, we are here on the case of Bowers versus Tillman. I'm joined on the panel by Judges Cohen and Nardella. Each have 20 minutes aside for oral argument. Mr. Byrd, when you start, you can tell me how much time you wish to reserve for rebuttal. I'll try to help you in that regard, even though there is a clock on the screen. Also want to remind both of you that these arguments are being live streamed so that the public can view them. Okay, with that, Mr. Byrd, you may proceed.
Good morning. May it please the court. Good morning, everybody. My name is Attorney Jeffrey Byrd. I've represented Ms. Bowers both at the trial court level with respect to both of her trials and now also at the appellate court level. The essential theme of this case is whatever a court will allow is what will continue to occur. And the appellant maintains that the time has come for the court to strongly send a message to opposing counsel in this case as it relates to trial tactics that have caused multiple mistrials and multiple retrials to be brought to an end. There are 6 points that were advanced by the appellant on the direct appeal. There are 6 points on the cross appeal. In the interest of time, I could not possibly get to all of them. But the most egregious issue perhaps is the fact that defense counsel intentionally, and I submit underhandedly, violated orders in limine by knowingly including within a PowerPoint presentation during closing arguments records that were knowingly objected to and knowingly excluded by virtue of both a motion in limine and then an order granting such motion in limine.
Well, Mr. Byrd, let me ask you about that, because sometimes it's hard to follow a transcript with a large volume of exhibits. But it's my understanding, and correct me if I'm wrong, but on the second to the last day of trial, you all concluded the testimony, and then the defense was going to get a chance to put in exhibits into evidence, and then after that was done, you'd all go into closing argument. Is that correct?
Essentially, yes, sir. At the end of the 9th day.
Okay, I don't want to go into what happened off the record, but I do want to ask you. So was there just one record from the urologist that was included in the evidence initially?
There were actually, it came to be discovered.
Mr. Byrd, that was a no answer. Was it one record or not?
It was one record that was ultimately displayed by a PowerPoint, but I believe that there were
but it's one record, one page
that was displayed at trial. Yes, sir.
All right. And how many pages or records of the chiropractor? Was that voluminous or was that short, or help me out?
No, that was voluminous. The chiropractor had treated her for 10 years.
Okay. So there's one urologist record placed among the chiropractic records?
Yes, sir. It was slipped in between 2 chiropractic records.
Okay.
Was that PowerPoint provided to you in advance of the closing arguments?
That's an interesting question. I can't state with 100% certainty that it was given. It may have been given to me literally minutes before the closing began. It most certainly wasn't given to me at any time, days 1 through 9. And I don't believe it had been given to me an hour or so before the closing. So I'm trying to be direct with Your Honor, but that's my recollection.
And the relevancy, if any, of that document would have been the reason or who it was that referred your client to the chiropractor, correct?
That is what was argued by the defense. Yes, I took issue with that.
Well, but that was theoretically the reason for the admission, correct?
As advanced by the defense, yes, sir.
All right. And other than that, what substantively was contained within that one document that would so prejudice you as to require a new trial?
The face of that document itself contains all of the information regarding my client's excluded and withdrawn GI issues, Additionally, it came from a urologist who had never been identified to the jury nor described to the jury. So it would have been impossible for the plaintiff to even have explained to the jury who that doctor was, why the fact that that record, which occurred 8 months after she initiated care and treatment with her chiropractic doctor, was a red herring and had no validity nor merit to it. It deprived the plaintiff of any meaningful opportunity to even diffuse that bomb that had been dropped in the middle of closing arguments as to a piece of evidence that the jury had otherwise never heard of, and apparently, or not apparently, did directly contradict the actual testimony of the chiropractic physician and his medical treatment record that was received in evidence. So I hope that that adequately addressed your question.
Do you think that the jury would be able to ascertain that from this one document?
Well, it's not only that they could have ascertained that, but the plaintiff would have been deprived of the opportunity to even explain it away, number one. Number two, it was knowingly and intentionally slipped in between two chiropractic records and presented in such a way that it was made to appear that it was a chiropractor's records. That's how it was presented. And it was done, not just presented on a TV screen, but it was in bold red letters. There was yellow underlining. It was knowingly placed in there, notwithstanding the fact that it was absolutely the subject of a motion in limine and an order granting that, and an extensive written objection as it relates to that doctor's records and evidence. So with respect to that was knowing, that was intentional, that was designed to not only attack the credibility of the chiropractor, but also the plaintiff. And it further supported Mr. Goebel's ongoing theory that he advances in trial after trial as to collusion between plaintiffs and treating doctors and plaintiff attorneys.
Well, that's the same thing that you do. That's just the nature of the beast in these personal injury cases.
Respectfully, that is not what I do, number one. Number two, there were motions in limine that were filed and granted on the topic of Mr. Goebel's continuing ongoing theme in trial after trial as to collusion and fraud.
Mr. Byrd, we've been reading transcripts of your trials for, years. And so your suggestion that you don't attack the defense experts in the same manner is disingenuous of you to take that position.
Respectfully, sir, I don't attack defense attorneys, experts in that same fashion to suggest that there's fraud and collusion between the attorney and the expert.
Yeah. Let me say, Mr. Byrd, I'm looking at this case in two perspectives. One is the perspective whether there was prejudice and that is resolution of this case, whether there's prejudice, whether there's preservation, et cetera. But I think there is also a bigger picture, and that is attorney conduct. I can't help but notice what both in this case and the case we have later today, what trial judges have said about the professionalism or lack thereof of the attorneys. And I have, and Mr. Rod, I'll tell you right off the bat, you'll need to address this. I have great concern about what appears to have been done in closing argument, and whether that was a subterfuge. My concern on that, though, is if, unless you meet the level of prejudice required, Mr. Byrd, to me, the action there is, if the prejudice isn't there, doesn't stick out, then the appropriate action is really to take action against Mr. Goebel, because if the facts are as you represented, then I have major concern with Mr. Goebel's conduct. But that doesn't resolve this appeal.
Well, and interestingly, Judge Evander, that's similarly the approach that Judge Thompson, I believe, had taken with respect to both his verbal statements and his order relating to reporting the matter to the bar. But the fact of the matter is it's my client who is damaged in the process, who is prejudiced. That's
the first perspective I talked about is,
yes, sir,
is the level of prejudice and any preservation issue. So,
Well, my client is made to look like a liar based upon this record that was slipped into evidence. Her treating doctor, who treated her for 10 years, who I would submit was the foundation of all of the medical testimony that came thereafter, was made to look like a liar by doing this. And in as much as then there was reference to a continual referral relationship for which there was no record evidence of, by the way, between the chiropractic physician and myself, when you make the plaintiff's lawyer, and then the plaintiff's treating doctor all look like liars, that meets the very definition of prejudice. It vitiated my client's ability to obtain a fair trial in this matter.
let me ask you.
And the plaintiff,
You objected to that statement in closing. The judge removed the exhibit from evidence, gave an instruction to the jury. Was there a motion for mistrial that followed immediately after that?
there was, sir, and it was not ruled upon, sir.
Okay.
Whose
So
obligation is it to obtain a ruling on a motion for a mistrial like that?
I'm sorry, sir, you broke up.
Whose obligation is it to obtain a ruling on a motion for mistrial? If you make a motion for mistrial and the trial judge doesn't give you a ruling on it, whose responsibility is it to secure a ruling on it to preserve that issue for appeal?
I suppose, as your honor has phrased it, that would be on me, I suppose, as you have phrased it. But I will submit to your honor that if you look at the transcript, there was essentially a war zone going on at that time, that the court is demanding to look at the records, the evidence. They were being searched for, they're being found. I make my arguments. I have to find the order of Judge Weiss that had granted the motion in limine striking it. I asked for a motion for mistrial, and I did not find in the transcript that a ruling was made on the motion for mistrial. Having said that, the judge post-trial denied plaintiff's motion for new trial on the same basis. So one could surmise that if it wasn't sufficient to grant a new trial, it would not have been sufficient to grant a mistrial.
Mr. Byrd, when I look at the transcript that's going on in that moment, and when you ask for mistrial, you state as follows: now for the record, I have to either both move for mistrial or ask for a curative instruction, and ask that the jury will disregard not only his commentary, but that which was put before the jury. And the court responded, thank you, I will, and granted a curative. Do you think that's a clear enough motion for mistrial for the judge to grant or deny? Or do you think you're giving him the option and he takes the curative?
In hindsight, I should have not used the word or, so I do see your point. But with respect to the curative, even the curative wasn't, in my opinion, strong enough to have actually cured the prejudice to the client, in as much as it didn't actually explain to the jury that which was done that was wrong, that was improper. So the jury, who has now spent,
Did you object?
gosh, it wasn't on a timer.
Did you object to the curative instruction?
I cannot contend that I objected, Your Honor, based upon my memory of the transcript. I don't have that in front of me, but my recollection was that the statement was given to the jury to disregard that which had been said. But even curative instructions themselves alone are not always sufficient, even when given, to cure the type of skunk in the room that had been done by Mr. Goebel. And by the way, that's only one of 6 issues.
From an appellate court perspective, you have an obligation to preserve that issue by objecting to the curative instruction that was given and giving the trial judge an alternative requested curative instruction, and you did neither. I just don't see how you preserve that for appeal.
Respectfully, plaintiff moved for mistrial. It was not granted. Plaintiff thereafter moved for new trial, which was denied. The appellant maintains that it was preserved for appellate review. Candidly, putting it under a microscope now at this time, sure, there are a few more procedural things that I could have done, but clearly the issue was presented to the court for its consideration to understand the level of gamesmanship that had occurred in a setting where the defense hadn't even offered its evidence until literally moments before closing argument was to commence. In a setting where it was requested that the evidence be disclosed to the plaintiff so the plaintiff could have even prepared a meaningful closing argument with respect to the defendant's intended evidence.
Mr. Byrd,
Yes,
let me
sir.
ask you this. Of your other issues you raised, which one do you think is your strongest one?
Well, that's,
I'm just
guess
trying to help you out
always
in
in
the
the-
time frame here.
yeah, that's always
Because
an
we've read all the issues, we've read the briefs, we've had, we're pretty attuned to what the arguments are. So I'm just asking what you think is your next strongest argument on the other issues.
Respectfully, there are 6, and I haven't even hit the highlights, but the court did not apply the special standard in ruling on the post-trial motion. Instead, it relied upon an older standard, which was the manifest way of the evidence.
Mr. Byrd, if you make an objection at trial, you think that the trial court should engage in a harmless error analysis?
Sir, with respect to the motion, post-trial motion, I would say yes. At trial, no, that's not the standard of specialty BOCA. So post-trial,
You're asking a trial court judge to utilize an appellate court standard and ruling on a motion for new trial.
post-trial, yes, sir. In fact, the plaintiff or the appellant briefed multiple cases where trial courts are held to utilize the same standard, the specialty BOCA standard. That was thoroughly briefed by the appellant herein.
All right.
So
Mr. Byrd,
that
you're
standard,
down to 3 minutes and 45 seconds. Do you want to reserve the rest of your time for rebuttal?
yes, sir. Thank you so much.
All right, thank you. Mr. Ryder.
Thank you. Good morning. May it please the court. Jack Ryder on behalf of the defendants in this case. I will start and go right to the closing argument issue, which obviously has dominated Mr. Byrd's presentation and the questions from the court up to this point. Let me start by noting that the order in limine that was at issue.
Well, I know you want to discuss the order in limine. You mentioned that in your brief, but I want to talk about the idea of sticking one document in the middle of hundreds of others. Is that what happened here?
I would respectfully disagree with that, Your Honor, and I'm going to explain
Well,
why.
let me ask you this. Was there one page of the urologist record put in?
I'm sorry, I didn't hear you, Your Honor.
Was there a single page and one page only of the urologist record put in?
I believe technically there was one page and then the highlight of the part that specifically honed in on the issue relating
Right.
to bias.
And how many pages of the chiropractor records were put in?
I don't recall, Your Honor, how many trial counsel put into the.
Over
but there
100?
were- The
Over 100,
actual,
over 200?
Your Honor, the PowerPoint itself, I believe
No, I'm
was,
talking about the records that came into evidence that the defense put in.
there were probably hundreds of documents, Your Honor. I don't have an
So
exact
do you
count.
think the court should have a legitimate concern when an attorney puts in one page of a urologist record without making any mention of it into hundreds of pages of a different doctor's records?
Your Honor, I would respectfully just disagree with the premise of the question because you
All right,
said no
where's the
mention of
premise?
it.
How is the premise incorrect? Go ahead and tell me.
Because here's how, Your Honor, what the record may not have demonstrated was the amount of time Mr. Byrd and Mr. Goebel spent going through each page of the PowerPoint before it was utilized. And Judge Thompson at pages 3152 through 3154 of the transcript describes how it happened. And essentially the documents, this is not a circumstance. And again, the record may not be clear, but Judge Thompson, who was there and observed it, was clear when he found on page 3152 of the transcript. And he states, this is Judge Thompson, I can't find, and it's my decision to make, that Mr. Goebel is in indirect contempt or there's a predicate for an issue of indirect contempt because of the documents that were in his exhibit when I asked both of you to go through them, to check them, and to make sure that what was being presented to the jury was agreeable to both parties.
Well,
And
let me ask you about something else that Judge Thompson also found, and as you indicated, he was the one there.
Yes, Your Honor.
This exhibit wasn't evidence. he took it out of evidence. Would you agree that's a rare occasion?
Your Honor,
Yes or no?
is it rare? Yes, I think it was rare, and it was just.
And it's done because the judge has determined that it was improperly inserted there. Now, it can be improperly inserted there inadvertently or intentionally. I think we can all agree it wasn't inadvertent here since it made it into a PowerPoint presentation. Would you agree with that?
It was not an inadvertent utilization
Right.
of the document.
So Judge Thompson implicitly found that that document was improperly and intentionally, well, improperly asserted, and we can all agree is intentional, because he took it out of evidence. Now, he may not have decided to hold Mr. Goldman contempt, but for a trial judge to take something out of evidence that has already come in, he's making the determination that that document shouldn't have been put in the first place. And, you know, I've handled lots of cases as a trial judge, and I know Judge Cohen as well, with lots of documents. And usually when that happens, it's because of inadvertence. But this is clearly not that case. And I'm just asking you point blank, do you consider that to be a professional and ethical act by Mr. Goebel to not disclose verbally, oh, I put this one page of the urological record in among all these chiropractic records? Yes or no?
Your Honor,
Yes or no?
Your Honor, I'm responding on behalf of the defendants, and I
I know.
understand the court's question about.
But you know, it seems to
And
me
here's,
we have.
I'll
a
answer the
duty-
question, Your Honor.
Hold on, sir.
Yes,
We have a duty beyond resolving this case. We have a
Yes,
duty
Your
to
Honor.
the court system. And it seems like the attorneys below really failed in that duty to the court system. And, you know, we may have a duty from our perspective to address not only the resolution of this case, but this type of action by an attorney. And so that's why I'm asking you the question I'm asking you. I know you want to talk about resolution of the case, but just because the duty that the attorneys owed beyond that, you know, was ignored below doesn't mean we're going to ignore it.
I'll answer the question, Your Honor.
Right.
I do not believe that the conduct here was unethical, just as Judge Thompson did not find it to be unethical. The
Oh,
reason
no. There's a big difference. There's a big difference between not finding someone in contempt of court and finding they acted unethically. So don't go on that argument.
Your Honor,
In fact, you know, Mr. Judge Thompson's comments were that the proper way to deal with this is the bar. So he did not say, no, this was unethical, or no, this was not unprofessional. He avoided that other than by his action of removing that exhibit from the evidence.
so I'll explain why, Your Honor, I would respectfully submit it wasn't unethical conduct.
Okay.
The order in limine, and I know you didn't want me to discuss that, but let me, if I may, provide context. The specifically excluded issue was not to discuss the plaintiff's urological and gastrointestinal issues. And that was not done. The fact that there were, and to be clear, and we noted this in our brief, the plaintiff introduced at least 6 different exhibits that had references to bowel or bladder issues. And it's clear here, Your Honor, this was not, and Judge Thompson noted that at page 3080 of the transcript, Judge Thompson agreed that Mr. Goebel did not make a reference to alternative theories or the stricken information. So the PowerPoint was put up, and the emphasis of the document was on the fact that there was a reference to a referral by the chiropractor or by counsel to the chiropractor. Now, that was the only point that Mr. Goebel referenced. It was objected to. Judge Thompson ordered to have it removed, instructed the jury to disregard it. But after the issue had resolved, or after the matter after closing was over and the parties examined it and Judge Thompson explored this, he did note that while, number one, while the urological document, it did come from a urological record, Judge Thompson made note of the fact that it was not placed on the PowerPoint with the intent to highlight those excluded points. So, you know, going back to what was—
So you think if it doesn't expressly violate an order in limine, it is okay for a lawyer to slip in one page of a medical record from a doctor in with hundreds of pages from another doctor into evidence without any type of disclosure. Is that your argument?
Your Honor, that is not my argument,
Well, because
I don't think that that's what happened here, Your Honor. In other words, I'm not,
well,
I am not arguing.
did Mr. Goldwell ever say, you know, Judge, just so there's no question about this, I am including in these my exhibit, my large exhibit here of composite medical records, one record from Dr. Thin, I believe his name was, and we don't believe it violates the order in limine, but I want to make sure that there's no question about it, because your order in limine says this, and we don't go into that. Was there anything like that, or was it just stick it in the middle and see what happens?
Your Honor, there was no discussion as Your Honor described it, but I do disagree respectfully with the describing it as stick it in the middle and see what happens, because
with all due respect, I mean, I said this to Mr. Byrd, but and I say it to you as well, which is we've seen transcripts over and over again from Mr. Goebel, and so you have to understand that we have a certain context of this too, that we see case after case where there is sharp practice, where there are all kinds of ethical issues involving, Mr. Goebel, and you have to understand the context that we come from, with these issues. Why should we give Goebel the benefit of the doubt? Do you think that he has earned the benefit of the doubt in this context? And even when you go up, when there's an objection made, he leaves it on the PowerPoint. He leaves it up for the jury to see, knowing that there's an objection and knowing that you're going up to the bench to talk about that issue. I mean, it just seems that, this is just a sharp practice.
Your Honor, I understand the court's point. And I also know that there's going to be an argument a little bit in a short while where Mr. Goebel will be before this court and will address questions about, and I'm not trying to in any way dodge the question, but the question is, to ask about Mr. Goebel and Mr. Goebel's conduct. And my point is, respectfully, I don't believe, and this goes back, Judge Evander, to the point you made, I don't believe that anything that happened in this case that counsel has referred to in the brief or today in any way impacted the outcome of the trial. And so obviously, while I want to answer the court's question and intend to do so to the best of my ability as it relates to anything involving the conduct of counsel, here in this instance, I can absolutely state based on this record, it had no impact. And more importantly, Judge Thompson, who oversaw this trial and wrote a very detailed order denying the motion for new trial, was very specific in his recitation of the hotly disputed facts and the multiple inconsistencies from the plaintiff herself on the witness stand, who had a lot of different, she lacked credibility. And I think Judge Thompson saw that, and he noted that in the order denying the motion for new trial.
Let me ask you this on the no
Yes.
impact. If it had no impact, what is the reason to put it in the first place and risk the court's ire by putting in a urological record in among a bunch of chiropractic records? I mean, wasn't the goal to have an impact?
Your Honor, it was to have an impact, but the impact was not to emphasize plaintiff's urological issues in any way. So
but you put in a document that said that she had been referred to the chiropractor by her lawyer, when the only evidence that had come in prior to that was to the contrary, and there was no opportunity to respond. So the purpose of that was obviously to create an impact.
Absolutely, Your Honor. And I don't believe that there's anything improper about presenting a piece of evidence that demonstrates a inconsistency by an expert who specifically, and again, whether it was
had to be admissible. You would have had to have had a grounds for the admission of that document, which is clearly hearsay. So if that document were presented to a court and the objection is made, hearsay, it's not a business record, you haven't established it as a business record, how does that come into evidence?
Well, I understand, Your Honor. It was established as a record, a medical record. It was an authentic medical record. So I don't believe there was a hearsay issue, because had it been more thoroughly addressed, I believe it would have been considered to be a medical record and therefore admissible under that exception to the hearsay rule. But going back to the idea of the impact it may have had, or
Wait,
the reason.
but that was that argument made to Judge Thompson at the point that it was withdrawn from evidence?
No, Your Honor. And the reason it wasn't made was because I believe, and I also want to, I believe that the document was not on the screen for very long, by the way. The record, again, doesn't show how long it was up, but it was really just a matter of probably minutes, if not seconds. It's very difficult to gauge. But to be clear, Judge Thompson did immediately, or within a very short time frame, direct it be taken down, granted the striking of it, instructed the jury to disregard it. And I don't believe at that moment, Your Honor, that Judge Thompson evaluated whether or not it was or was not admissible, as much as Judge Thompson wanted to do whatever he could to ameliorate any concern, knowing that he could then deal with it once the jury was outside the room. So Judge Thompson, I think, did an excellent job in doing so in order to make sure that if it was improperly placed in front of the jury, that it wouldn't have a tainting impact and it wouldn't undermine the overall impact of the evidence, which is based upon the verdict. It didn't. And I think Judge Thompson, again, who was there, observed, and granted the motion or to disregard, and as I think Judge Nardella, you pointed out, Mr. Byrd gave Judge Thompson the choice, and when he said, I either have to move for mistrial or ask for a curative, and Judge Thompson gave the curative instruction, and Judge Cohen, as you noted, Mr. Byrd accepted that. And then he moved for contempt. He wanted to hold Mr. Goebel in contempt, and Judge Thompson said, no, I can't hold him in contempt when, number one, you and he, referring to Mr. Byrd and Mr. Goebel, sat next to each other and went through each document. And Mr. Byrd objected to several documents, brought it to Judge Thompson's attention, and those documents he objected to were removed. So going back to this notion, Judge Evander, that it was slipped in, and
When were the
documents
given to Mr. Byrd, and how voluminous were they?
There were approximately 100 pages, and I think Mr. Byrd would agree with this, but I don't have an exact count, but it was about 100 pages, and it was at least an hour and a half to 2 hours, I believe, before closing. And I can say that the two men went together through the documents, tab documents, and Judge Thompson observed that.
Let me ask you this. Did Judge
Yes,
Thompson directed that the records be produced to Mr. Byrd the night before?
I do not recall that, Your Honor. I don't believe so, but I don't recall that. And I don't believe that it was raised. Again, there was no indication by Mr. Byrd at trial that he did not have ample time to go through the materials. And during the colloquy, and as I pointed to the court, it's starting at around 3150 of the transcript, the colloquy makes it very clear that Mr. Byrd acknowledged that he went through the documents. Mr. Byrd acknowledged that he raised objections to certain documents. Mr. Byrd acknowledged that he had his own duplicate set and that the document was in his duplicate set. And I want to again point out that there are at least 6 documents that plaintiff put into evidence that had references to the urological issues,
Well,
the gas.
I understand your argument on the order
Yes,
of
Your Honor.
limine. And I think, I get it. There may not have been a direct violation of the order of limine. I just have, as anyone who's done construction cases, medical malpractice cases, things like negligence cases, even the discovery rules, when you produce discovery, you have to, divide them in such a way that it doesn't come off that you're hiding a document. And I just, got one urological record and there's no breakup of it. I just have a hard time believing that most attorneys would not expressly bring that to the attention of both the trial judge and opposing counsel. And to not do so is exactly the way, we just had an induction ceremony for new attorneys, new members of the bar. If that had come up as a question, I'm sure every judge on our court would have said, no, you don't do that. That's not professional.
Your Honor, I understand the court's point. And I think that when lawyers are in trial and everything's happening very quickly, and as Your Honor knows, sometimes things happen late in the day, late at night, last minute, things are being put together. Sometimes things aren't perfect. And the law says a person is entitled to a fair trial, but not necessarily a perfect trial.
There's
There
also
were
a whole lot of lawyers who've gone their whole career without having been the subject of orders granting mistrial based on attorney misconduct. So I don't really buy
Over
that
and
as,
over and over and over and over again.
I don't
Again-
really buy that as an excuse.
Again, Your Honor, I understand the point of the court. I do.
And I know
one
we're
thing
putting you on the spot. I know you're
No,
not
no,
the one who did this, but.
Your Honor, I'm happy. I mean, I'm here and I'm willing to address any
Okay.
question by the court. And I stand by ultimately the way Judge Thompson handled it. I know I've raised issues on cross appeal in our brief, but I stand by the way Judge Thompson ultimately addressed the appellant's issues. And I stand by the way Mr. Goebel ultimately presented the case. And when he was told that he did something and there was an objection, he didn't try to re-argue it. One of the points that counsel to highlight, once this document was taken down, Mr. Goebel didn't go back and make other references to it. He didn't try and become like a repeat offender. He accepted the fact that it was stricken and he moved on. And it wasn't as
The damage had been done. He put it up there and it was highlighted, it was underlined, it was bolded. That he didn't have to do it.
And Your Honor, I'm sorry. Yeah, I was just going to say, in terms of the damage being done, I believe, as Judge Thompson noted, there was no damage done. And I also believe, again, that because the document did not draw reference to the prohibited issues, the urological or gastrointestinal issues, I don't believe that it, and as, again, Your Honor, perhaps it was a sharp practice to do so, but it wasn't a violation. It wasn't a violation of the order in limine. And it also demonstrated, at least had some reference to a potential bias. And going back to the impact and whether damage was done, Judge Cohen, the jury heard days and days of testimony, and Judge Thompson highlighted the many, many inconsistencies from the plaintiff about the history of her migraines, when the migraines started, about the severity of the accident. I know my time is up, but one last thing I'll say is the jury never even heard that the plaintiff was admitted to the hospital for a conversion disorder, not because of an injury to her head, not because of an injury to her back, not because of an injury to her neck. The jury never even knew that. And witness after witness after witness on behalf of the plaintiff talked about her concussion, post-concussion syndrome, and her acute injuries. And they didn't, with respect, according to the admitting records from the hospital after the 7-mile-an-hour accident, those injuries didn't even exist.
All right,
So-
let me stop you there. I believe Judge Nardella may have had a question, and then I'll.
Oh, I'm sorry, Your Honor. Did you have a question?
Oh, very quickly, where in the record do you base the time frame that you've given the court, an hour to an hour and a half for the review of records?
Your Honor, unfortunately, I don't know that that was referred to by Judge Thompson. I'm saying that because I was physically present in the courtroom at the time. So I shouldn't go outside the record. I'm going by my memory. So I can't affirmatively state how long it was, but I can affirmatively state that it was sufficient time for the lawyers to review the documents together and for Mr. Byrd to raise certain arguments about other documents that the judge excluded. And I do not believe that at any time did Mr. Byrd say, Judge, I need more time. I haven't gone through these. He acknowledged that he had reviewed them before they were utilized. And I know my time is up. So yes, Your Honor.
You don't recall whether Judge Thompson had ordered them to be produced the evening before?
I do not recall, Your Honor. I do not recall, and I do not believe so, but I cannot absolutely state, but I do not think so. I don't recall.
Okay.
All right, thank you.
Thank you, Your
Mr.
Honor.
Byrd, rebuttal.
All right, as to that last issue, the record is clear that Judge Thompson did require Mr. Goebel to give me the documents the night before. And I had asked the court to make that happen, and the court said that you all can resolve that issue yourselves, be here at 8:30 tomorrow morning. And then indeed, the record is clear that even when we arrived at court the next morning at 8:30, the defense still had not compiled its exhibits. And after waiting some period of time, then the court, which is the final day, the Friday before Christmas, mind you, the court told the jury to come back at noon, or maybe it was 1, for closing arguments to commence. And then even when the jury had come back, the defense still wasn't ready for closing. During that same gap of time, the record is clear that Mr. Reeder and I engaged in argument with the court over the jury instructions. So I'm sitting there dealing with those arguments at a time when then evidence gets handed to me. And Mr. Reeder is correct. I did find some things contained in there that I brought to the court's attention. But I couldn't find everything. Clearly, I didn't find this document that was knowingly the subject of a motion in limine and was knowingly the subject of an order excluding that specific doctor's records. So with respect, there was a requirement, and indeed there should have been a requirement to have the clerk mark the evidence at the outset of trial, which is what the plaintiff had done, which is what at the earlier mistrial, Judge, oh goodness gracious, I've forgotten his name. LeBlanc. I apologize to Judge LeBlanc. Judge LeBlanc had noted in his order granting a mistrial that evidence wasn't pre-marked by the clerk in conformance with that court's order. So I do think that the record is clear that Mr. Goebel had a duty to provide it and chose not to.
All right, Mr. Byrd, let me talk a little bit about some of the submissions that have come in over the last couple days in this case. Now, none of them were part of the record below, correct? Because they've occurred subsequently. Some of it that has occurred subsequently, right?
I'm unclear what submission. If you're referring to our oral argument at 11 o'clock, there was a submission over the weekend.
Okay. And do you think that you can do that? You think you can? You're not giving us new case law. You're trying to add things to a record without, filing a proper motion.
I do not know what.
We'll deal with that in the next case. So let's go ahead and let you finish up.
And I had not fully addressed your question, Judge Vander, when you asked what other issue. I don't have time, clearly, with 30 seconds left, but there was an issue as to the repeated reference of the plaintiff's missing chiropractic records and the fact that she naturally had to have been treated for prior neck and back problem when there was not one scintilla of evidence to support that. In fact, the evidence that Mr. Goebel was aware of was that she had fractured her kneecap and that was the reason why she had previously seen a chiropractic physician. But notwithstanding that expressed direct knowledge as to that prior issue, there was repeated references throughout the trial of the plaintiff's missing chiropractic records, which was the basis for the new trial being awarded in a case called Plotkin that this court affirmed when new trial was granted in that case. I see that I'm also out of time, so let me just say in conclusion, the appellant would request that this court reverse for a new trial and remand on damages only, causation having been both conceded by the defense at trial and the court having directed verdict on the issue of causation. And I do thank you for your time.